Good afternoon.
Good afternoon.
Hi, Chairman Winslow, we're still gathering here.
Commissioner Reyes, again. Good afternoon.
Hey, Matt.
Yes, Chairman Winslow.
Am I coming up okay on the phone?
Yeah, we can hear you fine, and we're just in the process of turning the monitors on in the room. Chairman Winslow, we're ready here whenever you're ready.
Okay, good afternoon, everyone, and welcome to the January 10th, 2024 Delaware Public Service Commission meeting. At first, I want to just say that the commission and staff extends its thanks to all of the electricity crews out there working diligently to get everybody back online, and that we wish them well and safe in their work. We have a reading of the meeting minutes of December 20th. Does anybody have any changes or corrections to those minutes? Hearing none, Commissioner Conaway.
Move that we adopt the minutes as presented from December 20th, 2023.
I second.
Is there any discussion on the motion? Hearing none, Commissioner Correa, how do you vote?
I was absent in the meeting, so I'm abstaining from the voting.
Commissioner Conaway,
Yes, I vote yes.
Commissioner Drexler,
Aye.
Commissioner Gray,
And I asked the other fellow commissioners to speak into the microphone. I couldn't really hear the responses. Thank you.
I didn't hear any response at all. Are you going to vote, Commissioner Gray?
I vote aye. Yes.
Okay, thank you. I vote aye as well. Commissioner, let's see, Drexler, are you on board?
Yes, I voted aye. Can you hear me now?
I can hear you, yes. And we heard Commissioner Correa, but speak in a little bit closer to your transmitter, Commissioner Correa.
Yes,
The motion carries.
I liked it.
Is there anybody from the public here that wishes to make any public comment to the commission? Mr. Hardigan, is anybody there wishing to make comment?
No, sir.
Thank you. We're going to go on to the consent agenda. Commissioner Gray,
Mr. Chair, I move that the commission adopt the consent agenda as submitted.
I second.
is there any discussion on the motion? Hearing none, Commissioner Correa,
Aye.
Commissioner Conaway,
Aye.
Commissioner Drexler,
Aye.
And Commissioner Gray?
Aye.
And I vote aye, the motion carries. We have number one on the regular agenda is in the matter of the application of Delmarva Power and Light Company for approval of energy efficiency programs for electric customers and recovery model. We're considering proposed order number 10357. And whoever is going to be presenting, please just notify everyone and put your names on the record because I can't see you. Delmarva Power and Light.
I believe Mr. Jordan is going to lead us off because he has a very important guest today here with him, so I think he wants to go first.
Thank you, Mr. Geddes. Good afternoon, Commissioner Chair Winslow, Brian Jordan on behalf of Delmarva Power and Light Company. And I am joined by future co-counsel. She's currently 9 years old in fourth grade at Lancashire Elementary. Her name is Cheyenne Jordan. She's joining me today to observe and make sure that I do well. I say future co-counsel because she has a really great work ethic and she has a remarkable ability to persuade her grandparents to get her whatever she wants. So she's got all the characteristics of a good attorney.
Well, I take it she takes after her mother really well.
Yeah.
And Mr. Chair, may I welcome CJ to the proceedings?
Thank you. I can proceed, or if each person wants to introduce themselves individually, however. Okay.
Please proceed.
Thank you, Mr. Chair. Before the commission today is order number 10357, approving Delmarva Power and Light Company's energy efficiency program. To recall, Delmarva filed this back in June of 2023, and it initially sought approval of 4 programs: a behavioral program, an appliance recycling program, a quick home energy checkup program, and an Energy Star for new home construction program. The parties, I believe, engaged in good faith throughout the docket, exchanged discovery, and ultimately we were able to reach a settlement agreement on 3 of those programs. And those 3 programs are the behavioral program. That's the program where Delmarva will issue mailings to its customers that highlight how similarly situated customers use energy. And it's a way to compare your own energy use to your neighbors. The Quick Home Energy Checkup, which is a program that Delmarva will administer or will work with the Delaware SEU to administer, is a way to send out, amongst other things, contractors to homes to help homeowners identify areas where they could make energy savings, insulation, for example, windows, et cetera. And then finally, the Energy Star for New Homes program is a program that's new to Delaware, and it is an effort to incentivize builders to build energy-efficient homes using the Energy Star guidelines. The one program that was not included was the appliance recycling program. In addition, the parties also agreed on the cost recovery mechanism to be used for the energy efficiency programs. This mechanism is familiar to the Commission. It's the same mechanism that was used in Delmarva's previous energy efficiency program, and we are reusing it today, or with these programs. That said, I believe that the settlement agreement calls for rates that are fair and reasonable and just, and I would also like to extend my appreciation to all of my opposing and co-counsel, including at DENREC, at staff, and at the Public Advocate. It was a nice experience working with everyone, and I would urge the Commission to enter Order 10357. Thank you.
Thank you, sir. I believe staff next.
Yes, staff's happy to go next. Jim Geddes on behalf of staff. I support everything that Mr. Jordan and his co-counsels said in support of the proposed order. Staff supports the order and asks your favorable consideration of it. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. Gina Iori, Deputy Attorney General, on behalf of the Delaware Division of the Public Advocate. The only things that I would add to Mr. Jordan's presentation are that the behavioral program that he discussed is an existing program. The appliance recycling program that Mr. Jordan mentioned is also an existing program, but that was removed because, at least from the DPA's perspective, and I think from staff's as well, it was not cost-effective as measured by the EM&V regulations and as required by the Delaware Energy Act. So that was why we were not in favor of that, of ratepayers paying for that program. Other than that, we are pleased with the settlement, and we hope that the commission will consider it favorably. Thank you.
Thank you, Ms. Ivory. Is there anyone else who's a party to speak? I don't believe so, but
On behalf of DENREC, and apologies for not being there in person. I wasn't anticipating our school district would close today. It sounds like Mr. Jordan may be in the same boat, but was more brave about bringing his children to attend in person than I am. I believe Tom Noyce may also be there in the room. DENREC, like everyone else said, DENREC appreciated the collegial manner in which the parties addressed this docket. DENREC signed the settlement agreement and supports the settlement, and urges the commission to adopt the order. Thank you.
thank you very much. And I believe that's everyone now. Commissioners, do you have any questions of the parties?
I would move
May we have-
that we adopt proposed order 10357 as presented.
I second the motion.
Is there any discussion on the motion? Hearing nothing, Commissioner Correa, how do you vote, sir?
Aye.
Commissioner Conaway,
Aye.
Mr. Drexler,
Aye.
Commissioner Gray,
Aye.
and I vote aye as well. So proposed order number 10357 is approved. Thank you all very much.
Thank you.
Number 2 on the calendar is in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates. And we have the staff's interlocutory appeal to hear. And we acknowledge, and I believe you want to see copies of slides that were sent out on behalf of staff prior to the meeting. So if Mr. Geddes would commence the discussion on this application.
Yes, thank you, Mr. Chairman, members of the commission. Good afternoon, Jim Geddes on behalf of staff. I hope you're someplace warm and not dealing with a lot of tree branches. In any event, may it please the commission, staff appreciates you're taking the time to hear this appeal. Staff believes it's an important issue, one that is relatively novel, if not completely novel, in this jurisdiction, at least with respect to this utility. Staff is not seeking the commission's approval on the settlement agreement or approval of staff's position with regard to the settlement agreement. All staff is seeking is your permission to bring the matter directly before you for you to hear the testimony in favor of the settlement agreement and the testimony presented by staff that opposes certain provisions. Why is staff doing this? This is not the normal course. As we just went through in the first item on the regular agenda, it was pretty smooth sailing for everybody who was involved, same parties. This one, not so much. Staff has strong opinions, not opinions, but testimony that it believes is consistent with the commission's policy, as well as issues that it believes that the commission should consider in connection with determining whether the rates under the settlement agreement are just and reasonable and in the public interest. Those are the important criteria that that the commission needs to consider. So what I would like to do with my time is first reserve a few minutes for rebuttal, since it is our appeal, and start with a couple general principles, some observations, and then a couple specific examples of why staff is here today. Could you out, and can somebody put these up on the screen? Thanks. I'll give everyone a minute. Mr. Bowman Bowman is handing out the exhibits. These are not exhibits, they're just slides. So if I might start, I captioned these as guidelines, and I think the first point is an important one, is that the commission controls its own dockets. The commission decides how these dockets are going to be resolved. Sometimes you send them to a hearing examiner, sometimes you hear them directly. This case has been sent to a hearing examiner. We had a hearing on December 4th before the hearing examiner. The commission regulates through rates. I think too often we forget that all the information that comes before this commission and dealing with revenues and policy and other issues all ultimately ends up in rates. That's what the commission regulates. And those rates, as we have heard in the prior case by Mr. Jordan, he put the word fair in there as well, but just and reasonable and in the public interest. The other item that I think is missing as we go through these examples is costs. Rates are based on costs, the cost of service. And that is the area and how those costs affect particular customers. Some perhaps differently than other customers. That's something we'll talk about. And all settlements obviously must be in the public interest. Now, as you know from the motion that we filed, or the petition, I'll probably refer to it as motion, but it's a petition, force of habit, and the response, there is a settlement in this case. Originally, the company filed in December of last year. I guess it was December of 22. Time flies. An application for $72 million. In July, you approved interim rates in the amount of $55+ million. I think it was 55.5. The settlement is lower than that amount. It's 42.2, round numbers. So at the moment, the settling parties acknowledge that the interim rates are over collecting revenues by $13 million. So maybe since I've started down this path, I'll stay with it. That brings me to the issue of the extraordinary nature of this relief. One of the reasons why staff wants this case decided promptly is, one, the settlement agreement indicates that additional monies are being paid by ratepayers over and above the settlement amount, and staff's case is even lower than the settled amount. That's not before us today, but it's just part of the context. And staff is interested in getting these monies back to ratepayers as soon as possible. Now, under the statute, the Reg Statute 1003, it is true that these monies will be returned to the ratepayers with interest. But that statute was created in 1985 when the prime rate was 15. The prime rate today is 8.5. I would suggest to you that there are very few people, well, I'm not going to say that. There are very few customers, I would include myself in that sentence, who could get rates at 8.5. I know Commissioner Drexler will probably tell us, yes, that's probably true. But we also know that credit card interest rates are extremely high, 19.99 if you have one of my credit cards, which is a big difference between 8.5. Now, credit card rates have not gone down. 2 years ago, they were 13, 14%. Commissioner Drexler will know this as well, being a banker. Now they are almost 5% higher. So what's the point of this? Well, the opportunity cost for ratepayers is not 8.5%. As we all know from the from the press, not residential, but customers and the public in general is being hard pressed now for lots of reasons and are using credit cards for various expenses. And there's lots of press about how they're, certain people are being maxed out on their credit cards in order to try to pay bills. I think it's very important that this commission do everything it can to try to get that settlement, the one that is in this case that the hearing examiner heard on the 4th, and staff's case in opposition to it on some of the issues, monetary allocation of revenues, before you promptly. If you grant this appeal, this matter could come before you by the end of the month and you could have a refund order in place. If we continue down this other course, well, that might take longer. So why is staff seeking your intervention, if you will, here, now, in this matter? Can I have the next slide, please? These are just general principles, but the second one I think is more important, and that is when the commission approves a settlement, that settlement.
Your Honor, Commissioners, I'm going to object to this. None of this was in the interlocutory appeal petition, and the respondents have had no opportunity to respond to this. This is all new material.
Well,
I would add the slides that we're seeing today may have been provided to the commission, but they were not provided to Ms. Iori or myself.
they were not provided
and
to
this
the
is-
commission in advance. They were
this-
not.
Well,
Ex-
but the point
excuse me,
is
this is
that
Tim
the point is that these slides consist of argument that staff did not make in its interlocutory appeal petition.
This case is cited
Cited,
in the appeal docket.
really?
You're,
I think what Ms. Iori was trying to articulate, and
Your
maybe
Honor, if I may,
go ahead.
this is Tim McCormick from the Delaware Energy Users Group. I'm appearing telephonically. I can't even see these slides. They weren't distributed. So if he's going to continue, I would ask
Yes,
that
that's our,
the
I'm
slides
sorry,
be
Tim.
emailed.
Thank you, Tim. Good point. What I would add in terms of articulating, I think the point that Ms. Iori was getting at, and this is Ms. Schultz, by the way. For those of you on the phone, I haven't identified myself yet. I'm here on behalf of Delmarva today. But essentially, the point is the entire argument that you just heard with respect to the reasons why this needs to come before the commission was not in the petition by staff as the reason for its request.
These cases are not cited in your petition,
If you look
in
at,
the footnote or the text. I am looking at it, staff.
don't argue with me, I'm looking as well, so could I have a?
May I please have your
You
attention?
said it.
May I please have your attention? It seems to me that the slide is so basic that it really is of no harm to any party who so far has objected to its discussion. Quite frankly, it's so basic that I'm not sure it's on the table, but I would be more interested in hearing what the extraordinary circumstances are that cause this appeal and what substantial injustice or detriment to the public interest is supposedly occurring that we should prevent. So if we could get to the core of this whole matter sooner rather than later, and I'll give Mr. Geddes some leeway where he feels it might be important, but let's try to get through this and listen to Mr. Geddes, and maybe some of us might, well, object where you want to. I know you will, but go ahead, Mr. Geddes.
Thank you, Mr. Chairman, I will try to move forward. Can we have the next slide, please?
I would ask you to read the slide since
Sure.
apparently there may be persons on the phone who haven't gotten it.
All right.
This is Tim McCormick. I will say that I just received it via email, so at least I'm able to see it. I don't know about others.
So this is a rhetorical question as to why the commission, made the appeal. And this is, to answer your question, Mr. Chairman, these are some of the reasons why we seek to have this appeal heard by the commission directly, or heard the settlement agreement heard directly by the commission, because certain information that we thought was relevant to, in the context of considering the settlement agreement, was not included in the evidentiary record. In fact, it was specifically excluded. This particular slide shows, or at least illustrates, 4 areas in which information that the staff thought was important for the hearing examiner and the commission to have in considering the merits of the settlement agreement, which were excluded. Next slide, please. Now, this is also a rather standard principle, is that agencies such as the commission are not bound by the uniform rules of evidence. They are a guide, as specifically set forth in Title 26 and Title 29. Other jurisdictions have specifically said that evidence that would be inadmissible in a court may be admissible in an agency hearing. Again, we're trying to establish what is the public interest and whether the conditions in this settlement agreement meet that standard. Next slide, please. Now, these are the original rates that the company filed for, supporting the $72 million in additional revenue request. I singled out just one particular class of service, which is illustrative of why we believe this matter should come directly for the commission, this small general service category. The next slide, please.
Mr. Geddes, could I ask you, does someone in one of the parties represent that category?
The DPA
Small
represents,
general,
the DPA represents small service and residential.
okay, thank you.
The next slide is the settlement rates. The reason for putting these slides in is to show that the rates are different. These are not what the company filed for. It's not what the direct testimony supported. It's not what their rebuttal testimony supported. These are the new rates that the company and the other settling parties are requesting the commission to approve as part of the settlement agreement. This establishes that these are not the same rates, these are new rates. And in connection with new rates, it's staff's position that staff should have the opportunity, a full opportunity, if you will, to present evidence as to whether these rates as proposed are just and reasonable, or whether they instead, in staff's opinion, burden some rate classes, such as the small secondary class, with a revenue allocation that is not just and reasonable. Next slide, please. Now, this was a slide that was prepared by Dr. Blank. It was Exhibit 57, Attachment D to our petition. This shows how the allocation
Your
of
voice for me is going in. Mr. Geddes, I'm sorry, your voice is going in and out. Can you tell me what is red at the top of the slide you currently are referring to?
It says Exhibit 57, Attachment D. Larry Blank.
All right, I'm at the same place. Thank
Okay.
you.
I apologize for that. I pulled the microphone closer. This was staff's attempt to analyze the rates as proposed in the settlement agreement as they are allocated across the various classes. Obviously, this could not be developed before the settlement agreement. It was developed in response to it. Next slide, please. The hearing examiner, in excluding this information from the record, this particular slide, said, and I'm reading now from the top of page 366, should be the next page behind the table. The way that I view this proposed settlement agreement is that the parties are in favor of it, that the parties that are in favor of it have to argue within the four corners of the document to the commission that the commission should adopt it. And these are arguments that staff will raise undoubtedly that the commission should not adopt it. This is my point. You are eliminating the ability of staff to put into evidence in this record the reasons why it doesn't support the settlement, specifically the table that precedes this quotation from the hearing examiner. Next slide, please. Sorry. I have to use these glasses a lot more than I used to. I can't read anything. This is a page out of the joint selling party's response to staff's petition. I'm looking after footnote 12, line 3, stating, the hearing examiner agreed with respondents who objected to introducing uniform rate of return information because no such uniform rate of return information were specifically stated in the settlement by negotiated agreement. And this is the key point I want to highlight, including UROR information or testimony concerning same would be prejudicial to the settling parties and in contravention of the terms of settlement, which clearly states the percentage of the overall revenue requirement to be allocated to each class. Well, that's not the point. The point is, what's the burden on the classes with this additional revenue? We know what the percentage is, 6%, going back to my one illustration of the small service. And we know how many dollars, but we don't know is that fair in relationship to the burden of other classes in terms of how these revenues are being allocated. And in this, it's saying, well, that's not in the settlement agreement, so therefore you can't consider it, commission. I think that is incorrect. You must take all of the information that surrounds this settlement agreement, not just within the four corners, but all relevant information. Staff maintains that the allocation of revenues is material to whether these rates, as proposed, are just and reasonable to every class and whether they are in the public interest. Next slide, please. Now, this is hard to read, and you can't, it's impossible on that sheet. That's a placeholder. This is the actual exhibit. Now, this is a work paper that Delmarva sent to staff after a telephone conference with the hearing examiner to show the allocation of revenues across classes. And if you look at the top, you will see again, the secondary general service, that they are paying almost twice as much on a on a rate of return basis as the other classes. Now that is based on a cost of service that the company did. Not everyone agrees with that. I understand that. But it is a cost of service that staff relied on. It's a cost of service that the company showed us the allocation of those revenues under the settlement agreement. That was excluded. Next slide, please. Now, I was told when I asked to have this stipulated into the record, again, this is a paper that Delmarva generated on its own, sent to me by their counsel, and I was told in the top paragraph, Gina and I discussed your request. These work papers will not be stipulated as an exhibit. That type of information is provided by Delmarva later in the compliance filing with the rates and tariffs once the commission approves the settlement. The settlement agreement by its terms explains through the table of rates. And let's look at the bottom. Please let me know, this is an earlier email that day, please let me know if staff has any questions in order to assess the revenue allocations. So let's parse that out a little bit. Delmarva's counsel is telling staff that we can look at this information for purposes of determining the revenue allocations across classes to see if we'll support the settlement. But they're also saying in this email, your client, which is you, the commission, I work for you, can't see that information before you approve the settlement. Now, I think that's a little inconsistent, and I don't think that's particularly correct. I'll use that word. If the allocations are important for staff to understand in order to either sign on the settlement agreement or not, why are they not important for you, who ultimately makes the decision about the settlement agreement as to whether it's creating just and reasonable rates and is in the public interest? Next slide. Now, the hearing examiner, in denying this exhibit into the record, had 5 findings or 5 statements that he made. I'm going to try not to be, I'm not going to say that, strike that. Number 1 is it's not in the record, okay? We were trying to get it in the record. Number 2, Ms. Iori said it wasn't authenticated. Well, it was sent to me by Delmarva. Usually Delmarva sends accurate information. Maybe technically it wasn't created by my witness, but it was created by the company. The company is the one that's seeking the $42 million in additional revenues. I don't think that's a very strong argument. And you can probably take judicial notice of it if we were into the evidentiary rules. But as we say, those rules are guidelines. This is an administrative agency, not a court of law. 3, the document was created by Delmarva. Yes, it was created by Delmarva, which is one of the reasons why it should be admissible to determine whether this settlement agreement is in the public interest. It was provided to parties during settlement negotiations. It's not confidential. It was provided to try to persuade staff to agree with a settlement. And last, we could pursue it through Dr. Blank. Well, the exhibit is what's important. It's the allocation of those costs and your ability to see that at the time we present our position on the settlement. Again, next page, please. This is also page 5. Again, go with the glasses. Again, this is the joint settlers' response to our petition. The highlighted or bracketed language, the hearing examiner lists 5 reasons why he would not admit 58. Additionally, as argued by the settling parties at the hearing, UROR listed on the exhibit is inconsistent with the settlement terms and was not intended to be included in the record. Who was making decisions about intended in the record? I mean, the selling parties can't tell you what the record is. We have an opportunity to tell you what we think the record should include in our opposition to the settlement agreement, specifically with regard to revenues and allocation of costs. They don't have a unilateral right to tell you what the record is. You need all of that information to establish what the rates are, whether they are just, and whether they're in the public interest. Going back to the point that Chairman Winslow made, I do think early on in my comments, and I'm wrapping up, I did state why I thought it was important to have this matter decided quickly, because of the amount of monies that are owed to the ratepayers and the fact that their opportunity costs with regard to those funds is a lot different and a lot higher than the companies. So we are asking you respectfully to please consider the settlement, to have a hearing in 2 weeks. at your next scheduled commission meeting to consider the settlement agreement and staff's position with regard to it and refund these monies to the customers as quickly as possible. Thank you.
If I may, Chairman and Commissioners.
I didn't hear what you said after the word customers.
And refund the money to the customers as quickly as possible.
Is that the end of your comment, Mr. Geddes?
Yes, thank you, Mr. Chairman.
Thank you much. Who is next?
That would be me, Mr. Chairman, Ms. Schultz, on behalf of Delmarva. So in fact, Chairman and Commissioners, I am arguing on behalf of Delmarva and the DPA and Duke today, all of whom joined in opposition to the petition before you. Ms. Iori is also present, as is Mr. McCormick on the phone, and they may have additional points to make coming in behind me, but I am going to provide the argument in its primary form. So with that, I'd like to start actually, Chair Winslow, where your question was to staff, which is really derived
In and
from,
out on my telephone.
excuse me?
Likewise, mine.
Couldn't understand you, Commissioner Gray.
There's a silence now. I'm not sure if it's intentional or not.
We heard some feedback on the phone. We weren't sure if you were talking. I think Commissioner Gray piped in for a moment, but I will pick it back up. So where I think we ought to start here, Chair Winslow, is with the questions you posed to staff, which is tracking the standard for an interlocutory appeal to this commission. And that standard is in 2.16.1 of the Administrative Code with respect to hearing procedure. And it requires that interlocutory appeals during the course of a proceeding may be taken by any party, quote, only where extraordinary circumstances necessitate a prompt decision by the commission to prevent substantial injustice or detriment to the public interest, end quote. And so in this instance, commission staff in its petition did not articulate any extraordinary circumstances that necessitate that the commission take action to somehow remove this case from the hearing examiner, nor did it prevent any notions of substantial injustice or detriment to the public. You heard today for the first time Mr. Geddes make arguments regarding interest rates and the interim rates, but respectfully, interim rates and rate case proceedings are always put into place, and they are put into place subject to refund, and they are refunded once a final commission determination is made and the rates are put into effect. That argument that you've heard, which appears to me, from what I've heard today, to be the primary basis upon which staff is arguing that this commission should take the matter immediately, is an argument that could have been made in November, in December, prior to having a full one-day evidentiary hearing where multiple witnesses were presented and live testimony was received by the hearing examiner. It's no different today than it was a month ago. And there is a procedure and a process for this commission to revoke the designation of the hearing examiner and to hear a settlement in the first instance on its own accord. And in fact, in prior cases, in the last gas-based rate case for Delmarva, where a settlement was reached, and I believe that was docket 22-0002, the parties filed a joint petition to the commission seeking to revoke the hearing examiner's designation and to present that settlement directly to the commission. That could have been done
We
here.
have guests signaling us to let us know that we cannot hear you. I don't know if y'all want to dial back in or try and fix the mic issues, because on our end, everything's coming in clear, but our guests are having a hard time hearing everything you're saying. About every other word is cutting out, and there's significant silence on this call.
Yeah, the audio in the room is fine, so I would suggest the guests try to reconnect.
Commissioner
I
Wynn,
would highly recommend maybe disconnecting and dialing back in. That'll usually clear things like this up.
Let me, for clarification, please. can I ask, are you suggesting everyone clear out
No, sir.
and dial in
No,
again?
sir. No, sir.
All
Just the line that's cutting out. Everybody else's lines are working appropriately. They can hear. It's just it's cutting out so significantly that they're not really getting the content that you're giving them.
I completely agree. Thank you.
Okay, so if I may continue where I left off, my point. Oh, sorry. Are we waiting for specific people to join? I'll hold till I am told to proceed.
Ms. Schultz, is there any way that you can bring that even closer to you, like when you're eating the microphone? Yeah.
How's that? I know.
Yeah, maybe we can just confirm Chairman Winslow is still with us and Commissioner Gray and just go from there.
Matt, did you say something? Because you broke up as well.
Yeah, well, I'm practically eating the microphone. I just want to make sure that you can hear us and that Chairman Winslow can hear us. And if that's the case, we'll continue. Chairman Winslow, are you with us? So perhaps we could recess and I can try to contact the chairman?
Yes, please.
Welcome to the conference center. Please enter your moderator code or your participant code.
Your passcode is not valid.
Welcome to the conference center. Please enter passcode. Please hold for the next available operator. Welcome to the conference center. Please enter your moderator code or your participant code, followed by the pound sign. If you have difficulty,
Your passcode has been confirmed. Please wait while you are joined to the conference.
if you keep getting invalid, you'll come through to an operator. I'll pick you up and get you joined immediately.
Try to dial in, but usually the phone is louder. So I heard it on the computer.
This is Tim McCormick. Can you hear me still?
Yes, Tim.
Yes.
Yes,
Great,
Tim.
thanks.
If you keep getting invalid, you'll come through to an operator. I'll pick you up and get you joined immediately.
Okay, this is Dallas Winslow. I'm back on the line.
Thank you, Dallas.
Is Commissioner
Are
Gray
we
back?
ready to proceed?
Commissioner Gray?
Commissioner Gray is here. Thank you. Yes, I'm here.
Okay. Well, I will continue. I'm going to do a brief recap. I think it makes sense because I'm not sure how many words of mine you all actually heard. But essentially, what I wanted to articulate is that we're dealing with a standard that requires extraordinary circumstances. I don't believe that staff has presented those extraordinary circumstances to you, either in its petition or here today. The only thing I heard that came remotely close to a reason why staff wants this commission to somehow now take this case away from the hearing examiner following a full one-day evidentiary hearing on the reasonableness of the settlement agreement is because interim rates are in effect and customers might get a refund sooner. That is not a situation that is new. It is not a novel concept. That same situation, that same circumstance existed a month ago, and staff could have approached the parties with a request to make a joint petition to this commission to revoke the designation of the hearing examiner. That request was never made. The time to ask for such revocation would have been before the parties went through the work, the effort, the time to put on a full evidentiary hearing, which went over the course of a day, included 2 witnesses from Delmarva, 1 witness from DPA, statements from counsel for the other Southern parties, testimony from the Weldon Road homeowners representative, as well as presentation of an entire afternoon of testimony from all of staff's witnesses. And so to suggest that the hearing examiner is not properly appointed and in a position to resolve this matter and to answer the question of whether the settlement is in the public interest and to present his findings to you in the ordinary course through a recommended decision, to which I might add staff has the opportunity to take exception, is preposterous at this time. And it seemingly, to me, suggests that Mr. Geddes' corollary argument for doing so and making the request to you is based upon the evidentiary rulings that the hearing examiner made. And he seems to be presupposing that this commission would make different decisions were it in the shoes of the hearing examiner. But the point is, the commission deputized senior hearing examiner Mark Lawrence to preside over the case. He presided over the case. He heard the arguments as to each piece of evidence that Mr. Geddes has raised in his petition. He heard arguments for, he heard arguments against. He used his judgment and he used his experience and he used the contours of the rules and processes and procedures that he put into place in this case for the conduct of the parties to make those decisions as to whether or not evidence and or testimony would be properly included or excluded. And I think that his determinations should be given great weight, and I think that this commission should not seek to overturn those decisions on evidentiary rulings at this stage, nor should it opt to come in and usurp his role and take the case from him, because he was positioned to hear it, he heard it, and I think it would be extremely prejudicial to the settling parties to ask us all to come back in and have the same evidentiary hearing before this commission. The additional points that I want to make briefly in responding to some of the arguments that you heard from Mr. Geddes this morning, he articulated that one of the issues that staff has that it feels as though it wasn't heard on are that the rates that are being proposed in the settlement are different than the rates that were proposed in the company's application. Well, that's customary. In a settlement, no party gets what they want. The parties come together, they hem and they haw, and they make agreements as to things to include and exclude, and they ultimately landed on a revenue requirement, which is what we did in this case. And this commission's job is to assess, you heard Mr. Geddes tell you, the reasonableness of the rates of the company. And the reasonableness of the rates and the testimony about that reasonableness was provided to the hearing examiner. And it is in the settlement agreement that this commission has the ability to see which classes are shouldering which percentage of the revenue requirement. It's actually page 5 in the settlement agreement, which was Exhibit D to our response to the petition. But you can see the revenue allocation, and it says very clearly what each of the rate classes, which percentage of the rate revenue increase each will bear. Specifically on the same page, it discusses the issue of the cost of service, the uniform rates of return that Mr. Geddes spoke to you about this morning on Exhibit 57 regarding Dr. Blank's discussion of URORs, or uniform rates of return. And respectfully, this commission does not need to be concerned with what the UROR is in the settlement. The settlement agreement and why it is contrary to put that evidence into the record is because the settlement agreement explicitly states, and I'm going to read it in section 2AD. It says, class cost of service study. The settling parties agree that the commission need not adopt any particular class cost of service methodology in order to find that the class revenue allocations are reasonable. This is not new language. This is the same language that appeared in Delmarva Electric's last base rate case settlement, which staff did sign on to. And so it is somewhat counter to say that now all of a sudden you have to see UROR information in order to assess the reasonableness of the rates when before you didn't. And if I go to the heart of why we objected and why the hearing examiner agreed and sustained our objection over trying to put in any evidence or exhibits that contained those UROR rates, is because that statement in the settlement agreement was something that all of the parties required. It was essential that there be no stated rates because Delmarva used one rate, the DPA had a different rate, Duke had a different rate, staff had a different rate. And what we all agreed on was the reasonableness of the revenue allocations amongst the classes. And so that is why there are no rates, and that is why it was inappropriate to try and put in Delmarva's settlement work papers, which you heard Mr. Geddes talk a little bit about, and which he read to you from one of my emails to him. But the fact of the matter is, the hearing examiner, in trying to elicit whether staff would agree to the settlement, had made a request that I share with staff information that it deemed that it needed to assess that, which is what I did. I provided those work papers in order to determine whether or not staff would sign on to the settlement, not suggesting anything by that. Now, Mr. Geddes read from an email I sent. He didn't attach the emails that came from me and from the DPA and from Duke's counsel with respect to that same exhibit, to which we all objected in advance of the hearing. And he didn't present them to the hearing examiner at the hearing either. So this was all raised and hashed out before the hearing examiner, and he still made the determinations that he did, and one of which, namely being that this is a document that was provided to the parties pursuant to settlement negotiations. So that information in there shouldn't be used and put into an exhibit in any way by staff in terms of opposing the settlement or not. I want to just make one or two quick points on the evidentiary ruling component of this petition, which is not something that was focused on much in the argument this morning. But this whole petition is really a matter of choices made by staff. And a lot of the hearing examiner's evidentiary rulings were based on the fact that staff elected not to do certain things in advance of the hearing, related to the procedural schedule, related to what the hearing examiner ordered. And it's on the basis of a lot of those that the hearing examiner decided to not allow staff to present certain evidence. Staff was given an opportunity to provide surrebuttal pre-filed testimony on Delmarva's 12-0 position that came in during rebuttal. It chose not to do that. Mr. Geddes admitted that in staff's petition. That was a choice that staff made. DPA filed surrebuttal testimony. And so it was entirely appropriate for the hearing examiner, when staff came into the settlement hearing, to say, no, you cannot present testimony on Delmarva's 12-0 position. One, because you had an opportunity to do that and you didn't do it. And two, because that's not what's before me. The 12-0 position is not before me. The settlement is before me. That is what this hearing is about. And secondarily, it's the decision to essentially try and put in as well information that the hearing examiner ordered that the parties exchange in advance. Many of the exhibits that were excluded were exhibits that staff tried to proffer directly through its own witnesses. The hearing examiner did require that the parties exchange any direct exhibits prior to the hearing. Staff chose not to do that with the exhibits that were excluded. And I want to make a point about Exhibit 54 in particular. I made it in the briefing, but Exhibit 54, staff seems to gloss over the fact that it never actually sought its admission in the hearing, so it would be entirely inappropriate for the commission to now determine that that exhibit should be admitted. And I mean, I could read to you the transcript sections where Mr. Geddes says just that, but I won't. It's on page 254 and 363 of the transcript, and it's cited in the brief. And I think ultimately where I will conclude is where I began, which is that the standard here is extraordinary circumstances. I do not believe staff has presented extraordinary circumstances, and I actually believe that there would be substantial injustice and prejudice to all of the settling parties if this commission were to essentially treat the entire evidentiary hearing as having not occurred and to force us all to come back out and relitigate that case over the course of a day. I mean, settlements are encouraged in part to save expense and to save time of having full evidentiary hearings. And that would be something that I think would just be extraordinarily prejudicial, and I think it's unnecessary. The hearing examiner made his decisions. He was the fact finder and the decision maker on evidentiary rulings in the matter, in the moment. There was no motion to revoke his designation, and there really is no cause to revoke that designation now. Thank you very much. I would request that the commission deny staff's petition.
Chairman Winslow, may I add a few?
Thank you very much.
Observations.
Ms. Iori,
Yes,
I thought she was speaking on your behalf as well.
she was, but she did say at the beginning that myself and Mr. McCormick might have some things to add when she was finished, but she would be doing the primary argument.
Well, I agree. She said that, and I'm going to let you speak, but I would just suggest to you that she had quite a bit of time, was pretty thorough. If you would be kind enough to keep your comments as short as possible.
I will
Thank you.
do so, Chairman Winslow. I don't intend to belabor this. I think really I have 2 points. One is that I think what is happening here is that 2 different things are being conflated. And one of the interlocutory appeal is on the evidentiary rulings that the hearing examiner made. You've actually got 2 decisions to make with respect to that. One, has staff met the criteria set forth in the commission's regulations? And I think Ms. Schultz addressed that. I will not belabor that further. But secondly, if you find that there were the extraordinary circumstances, then you have to decide whether they're so extraordinary that either staff has been prejudiced by it, or that we will be prejudiced by it. All of this stuff about bringing it before the commission for a decision is actually irrelevant to what the relief that staff has asked for in this interlocutory appeal. Now they throw in, oh, well, take it away from the hearing examiner and, let's have a do-over in front of the 5 of you. But that is not the issue here. It really isn't. Secondly, I hear what staff is saying about interest rates being higher now and wanting to get refunds back to customers as soon as possible. We would like to do that too. But I just have to point this out. Part of the reason that this case has taken so long is because it took forever to get started. Delmarva filed its 60-day notice back in October of 2022. Well, when they filed a 60-day notice, the reason for that, as stated in your regulations, is so that staff and the DPA, but your regulations only really address you, can make the necessary staffing arrangements, which includes outside consultants. Staff didn't have outside consultants on board until 3 months had passed after this case. Then it took a while to get a schedule in place. And then staff wanted to push the schedule out. So, excuse me if its claims about caring about customers rings a little bit hollow in light of what happened at the beginning of this case. Frankly, it should have been done by now. So with that, I will leave it at that. I would ask the commission to deny staff's application for an interlocutory appeal. Thank you.
Thank you, Ms. Iori. Mr. McCormick, do you want to say a word or two?
Very briefly, Your Honor. I would just say that I entirely agree with the points raised by my colleagues that by my colleagues, Ms. Schultz and Ms. Iori, and I won't seek to restate their well-reasoned arguments. I would raise and emphasize that the staff has simply failed to demonstrate extraordinary circumstances in this case. At heart, staff is seeking extraordinary relief to overrule fairly routine evidentiary and procedural rulings. I would urge the commission to consider the precedent that it would be setting by opening the door for interlocutory appeals of the kind of routine evidentiary and procedural rulings like those that are the subject of the staff's petition. So with that, I concur with the comments of my colleagues and would urge the commission to deny staff's petition.
Thank you, Mr. McCormick. Mr. Geddes, a few words in rebuttal?
Yes, a few words, Chairman Winslow. In no particular order, staff's concerned about the record below. I said that. Specifically, if you're a secondary customer and was told that you were going to, your rates were going up by $2 million as a class, 6%. 6% of what? I didn't say that correctly. 6% of what number? Without knowing that you already are paying twice as much on a rate of return basis as any other customer class, you would have no idea that your $2 million additional, 6% of the total, is on top of the fact that you're paying more than anybody else on a rate of return basis. That's important. The idea that previously in other cases we stipulated or whatever is because everyone did their internal analysis and said, no matter what your cost of service says, we think these rates are reasonable. In this case, and there are stipulations where we have in the past, I guess in the gas case, I was involved in that the parties jointly suggested that the matter, be directed to you. I think you can tell if you've read the transcript and you've heard the arguments. I was pretty unlikely in this case. It's a different case, different parties, different interests. My point being, you're entitled to this information. We represent the commission. These allocations are important for you to decide whether the rates as proposed are just and reasonable. The timing issue is, with all due respect, a red herring. Yes, it took a while to get the case going. Well, there were lots of parties in this case, more interveners in this case than there have been in the past couple. But once a settlement was inked, approved by the settling parties, it's there in black and white. These rates that were put in July are overcompensating the company by $13 million. And now time is of the essence. I think that is an extraordinary circumstance. But this is your docket. You need to make that decision whether you think that is an extraordinary circumstance or not. You have the power to, on your own, ab initio, if you wanted to, remove the designation of the hearing examiner. You ordered it. You can revoke it. With regard to the hearing before you, I'm not saying that we take the transcript of December 4th and throw it out the window. The commission can certainly fashion what it wants to hear, having read the transcript. Do you want to hear from the witnesses again? Do you want to have it supplemented? It doesn't necessarily go in the trash can. That's up to the commission. We're prepared to present our case, but we want to have a record before you. The only way this is going to happen is if you allow us to put this kind of evidence in. Did not go in below in front of the hearing examiner. It's important for your consideration, and therefore we request that you grant the petition. Thank you.
Thank you very much, Mr. Geddes. Commissioners, are there any questions of the parties you'd like to ask?
Commissioner Winslow, this is Chair Winslow. This is Commissioner Gray. So I have a question. I think I'll direct it to Mr. Geddes. Is the hearing examiner in this case expected to affirm in his report that settlement rates are reasonable, just, and in the public interest?
I would say that if he supports a settlement, he will have to have that as one of the reasons why he is doing that, because that's ultimately what the commission has to determine. just and reasonable rates and in the public interest. He is tasked by you to make findings and bring them before you that help you, make those determinations. Our point is the record's flawed and you can't make that in an informed basis. My responsibility to you for over 4 decades has been to bring as much information to you, good, bad, or indifferent, so that you, the commission, can make an informed decision. That has been my understanding of my responsibility, and I've tried to meet it. I'm sure I failed in some cases, but I think you need to have this information. Whether you approve the settlement agreement or not, that's not the point at this particular juncture. It's you need the information to make the decision. I don't think this record gives you that information. That's why we're filing the appeal.
If I may, Commissioner Gray, this is Ms. Schultz. I'd like to actually directly answer your question, and that is to say, no one knows what the hearing examiner's decision is going to be. He has not provided anyone with any indication, and nor has he issued a recommended decision. But when he issues that recommended decision, staff and the company and the settling parties will have an opportunity to file exceptions to that recommended decision, and this commission would have an opportunity to have a hearing on those exceptions and to make a determination as to whether it chose to accept or reject the hearing examiner's report, whatever direction the hearing examiner decides.
All right, I understand the fact that we haven't seen the final report, but it was more the question as to what we would come to expect to read in that report. And I think what I heard was that we would expect that report to say that the rates are reasonable, just, and in the public interest. And that was a follow-up. You've answered the second question. Will staff and other parties have opportunity to object to the final findings? And I think you've answered yes. And the last question I would have, Mr. Chair, is are the definitions of these terms, just, reasonable, and in the public interest, variable by different parties or consistently perceived to be defined the same?
I'm not sure, Commissioner Gray, was your question directed to counsel? The company, Mr. Geddes, Ms. Irie?
I'll start with Mr. Geddes, and you can supplement as well a response from your perspective in terms of whether or not you think these terms are defined variably by different parties.
I will say the following. The commission are the experts. You are tasked by the governor to regulate this utility, all utilities, public utilities, and in your infinite wisdom, you decide what's just and reasonable. I may have a different opinion, but I am not the decision maker. I am trying to make sure that you make the best decision that you can, whether you agree with staff's position or whether you don't. But ultimately, it is the commission that decides what is a just and reasonable rate and whether they can put 5 signatures on the order that implements those rates.
And Commissioner Gray, this is Ms. Schultz. I think I can add a little bit of clarity and context to that on top of what Mr. Geddes said. And that is that, the hearing examiner, in rendering his decision, is looking at the question of whether or not the settlement as a whole and the rates contained therein are in the public interest. That's the standard that's found in the statute in 26 Delaware Code Section 512. And I think it's important, Section C is where we're at in the context of this proceeding, which says that the commission may, upon hearing, approve the resolution of matters brought before it by stipulations or settlements, whether or not such stipulations or settlements are agreed to or approved by all parties, where the commission finds such resolution to be in the public interest. And I would agree with Mr. Geddes that the commission is deemed to be an expert in this area, has the expertise to determine whether the rates and the terms and the settlement as a whole is in the public interest, but so too does the hearing examiner in the first instance when he's been deputized as the expert to hear those matters and to adjudge the evidence in the first instance by the commission to present his recommendations, which again, this commission may agree with and may not. Thank you.
Thank you, Ms. Schultz. Mr. Chairman, I'll yield at this point to my fellow commissioners.
Are there any more questions, commissioners?
Yes, this is Commissioner Drexler. I guess I'm trying to determine a timeline here. regarding, and I'm focused on, because in reading everything, I'm focused on the exhibits. And, you know, I read about surrebuttal testimony. The staff assumed, I shouldn't use that word, assumed intended, I'm not even sure that's right, to introduce this evidence, these exhibits, in the 8-hour evidentiary hearing, but chose not to introduce these exhibits in surrebuttal testimony rather. So then I'm reading, here's the evidentiary hearing, and these exhibits are being introduced and being excluded by the hearing examiner. Is that what is leading us to this point, number one? And two, are these 4 exhibits, if you exclude Exhibit 53, which is rather controversial, but if you take these 4 exhibits that are so vital, is that changing the settlement agreement?
Point of clarification.
Yeah.
I think your first point is not consistent with what staff understands occurred. First of all, we had the opportunity to file surrebuttal testimony after the 12-0 was filed in September on November 1st. These exhibits do not relate to the 12-0. They relate to new rates supported by the settlement agreement. That was my whole point, is that we had no opportunity to review those new rates at the time of the surrebuttal testimony, because surrebuttal testimony was based on the 12-0, $53 million versus the 42. That's why I put those exhibits up for you, so that you could see that there was a difference. I did not put the interim rates up, but they were obviously in between the two. So these exhibits relate to the allocations in the settlement agreement and how they are unfair to these certain classes of customers. That's the first point, and I'm afraid I've lost the second one. It relates to allocations as a result of the settlement agreement. And I will agree, Exhibit 54, that was just a scenario of prior commission decisions. I didn't seek to have it included. It's in the record.
If I may,
Ms. Iori, I noticed that, okay.
Mr. Geddes just entirely mischaracterized all of the exhibits for you. I can tell you squarely, Exhibit 56 is Mr. Pfaff's 12-0 staff litigation position. So just want to make sure that point is clear.
That's a clarification that I can agree with.
And otherwise,
But not
some of the other exhibits, if we take, I think you said 53 off the table, which is the RRA article, then we're given Exhibit 54, which contains, UOR information, which was part of the settlement work papers, but explicitly not stated. And then we have Exhibit 57, which also has UROR information in it, and which was not pre-circulated, to your point earlier about exchanging timelines. And then we have Exhibit 58, which is entirely the Delmarva's settlement work papers. And so those are the exhibits. And to your question, I think your question, and I may have lost exactly what it was, but you had a question about if we get rid of these exhibits.
Not get rid of these exhibits, but without these exhibits, in the 8 hours of testimony and exhibits and during settlement agreement discussions, does it change the settlement agreement?
No. The settlement agreement is what it is. It says what it says. It explicitly states what it is relying upon and what it is not. And it provides for the revenue allocations amongst all the classes, and the tariff pages within it explain exactly what the rates are for each class that are resulting from the settlement. And Ms. Iori looks like she wants to say something.
Point of clarification.
Do I get to go?
You go.
Ms.
Ms.
Iori, please go ahead.
Thank you. I just want to add to that, because staff keeps pushing UROR and you need this information. I haven't been doing this quite as long as Mr. Geddes, but I have been doing it over 30 years now. And I wrote, drafted a lot of commission orders from rate cases. And honestly, I can't think of any commission decision in a rate case where the commission based its decision on the uniform rates of return for the various classes. What this commission has done is looked at the rates resulting from either the settlement, if it's a settlement that's being proposed, or if it's a litigated case, looking at the rates that come out of each party's litigated position and making its determination that those rates are just and reasonable.
Point of clarification, only because the one point you made, these are staff's exhibits in opposition to the settlement agreement. The settling parties want you to look at, I had an orb that, floats around, but, doesn't have any nexus to Mother Earth, but I took that exhibit out. Eclipse on April 8th. But the point is, there's no reference point. And yes, historically, maybe it wasn't important, but in this case, it is for the reasons I stated before. You need a reference point. You don't know why that 6% for a secondary class isn't 10% or 3%, because you don't have a basis on which to judge what that percentage and those dollars are affecting. That's the point, but these are our exhibits in opposition.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Commissioner Drexler. And that is incorrect. The settlement agreement shows what the percentage increases are for each of the customer classes. That is the basis on which you can make your decision. You don't need URORs for that, and you never have.
Thank you, Ms. Iori. Ms. Schultz, Mr. Geddes, I yield. Mr. Chairman.
Thank you, Commissioner Drexler. Are there any more questions? Okay, very good. I move that the staff's interlocutory appeal be dismissed.
I second.
Well, let's discuss this for just a few minutes. First of all, this has been a difficult case, and I'd like to express my appreciation to the parties for the work they did. It was not an easy one, and I also think it puts the hearing examiner sort of a difficult position, but in my opinion, Mr. McCormick and Ms. Schultz got it right, which is that these are sort of typical decisions made by the hearing examiner. There's nothing extraordinary about the well-known research organization that put together the article on settlements. Actually, it's a very interesting article, and staff should concentrate more on where they're getting better settlements. Also, if you look at Exhibit 54, you look at the record, I'll quote Mr. Geddes, where he says, with respect to Exhibit 54, quote, "I don't necessarily have to have it in the record," end of quote. And with respect to Exhibit number 56, quoted Mr. Geddes, "This is an aid to assist. It really does not move the numbers significantly." We've discussed the URORs, and I would disagree a little bit with Ms. Iori, despite her many years of experience, because my recollection is that the DEUG group brought a lot of perspective to this area and was successful, 9, 10 years ago, 8 years ago, in getting some changes made. So I think that the URR can be important. But in this particular case, I don't think it makes a lot of difference. Exhibit 58, that's the Delmarva thing, and I think it was a routine decision made by the hearing examiner. Nothing extraordinary, frankly, about any of these things. I just don't see that burden that the staff had to meet has been met. So that's the reasons why I make the motion to dismiss the interlocutory appeal. Any other discussion on the motion? Hearing none, Commissioner Correa, your vote on the motion?
Aye. Did we have a second to that motion? Okay. Okay, I missed that.
Commissioner Drexler, I think, seconded.
Thank you.
Commissioner Conaway,
Aye.
Commissioner Drexler,
Aye.
Commissioner Gray,
Aye.
and I vote aye. The motion carries. Thank you all very much. Let's see. I have somehow missed my agenda. I believe that we have Mr. Hartigan next. Matt, you're up.
Thank you, Chairman Winslow. Just wanted to mention our next meeting is January 31st.
Okay, does anybody else have a, for the good of the order? Everybody have a good day.
I believe Ms. Price wants to be heard.
Just for a second,
Yeah.
I wanted just to say that I've been doing this work for 41 years today.
Condolences.
Congratulations.
Congratulations.
Okay. Goodbye, everybody. Best wishes. Bye-bye.
Bye, thank you.